Here to talk to you about joint and several liability. I think we've all heard this many times. Matter of fact, we just passed it out of this committee, I think, an omnibus bill. I'm sure there's going to be people to testify, Mr. Chairman. Basically, what the gist of the bill is that if you are at fault, if you're a business owner or a private individual and you're declared to be 51% at fault, and the other person's at 49, you would only be responsible for 51%. They can't come after you just because you have more money than the other person to come after you and make you pay his portion of it too. So it simply says that you're going to be responsible for your portion and you can't be held responsible for any further portion than that.
The 60s and 70s, and I started practicing in 1972, at that time we had what was basically called comparative negligence. That is, if you were a defendant or a plaintiff in a lawsuit and you were 1% at fault, you were barred from any recovery. That was probably a pretty draconian result for someone who, and typically in accidents, there's usually some apportionment of fault. Sometime after that, and I will also tell you at that time, a wrongful death damage limitation in Missouri was $50,000. So we've come since that time a long way, and right now, the current law is if you are, in order to be jointly and severally liable, that is where you, one defendant, can be responsible for everything, you have to be 51% at fault. What this bill does is really essentially two areas. It sort of takes the 51% out of the equation and makes a person responsible for that percentage of his damage responsibility is equal to that percentage of his negligence that's assessed. That is, if you got 30% negligence, you're responsible for 30% of the damages, irrespective of what other defendants and stuff might be. And I know there's some machinations, and I don't want to be criticized for not completely covering it, but and I think that is incredibly and fundamentally fair. And this doesn't just have to do with insurance coverage. Let me tell you, there's a lot of businesses and others that have huge reserves and huge first levels of liability. So this can affect not just in whether you're insured or not, but whether you potentially have liability or maybe no insurance. The other thing that this bill does, it allows an assessment of fault against a person or an entity that was involved in the accident that isn't a party. It's not a named defendant in litigation. You might wonder who that could be. Well, let's use an example where there's an automobile accident and you sort of have a phantom vehicle. The car that crossed the center line put two other cars colliding in the ditch, and the guy that everyone agreed may have been sort of the principal cause of this accident, the phantom vehicle, he drives off, never to be found again. This bill would allow the trier of fact to assess fault against that person also, or that entity. And I think that's a change also that this bill does. I believe, I'm not sure exactly if this version was consolidated in the bill you put out in exec last week, in the consolidated bill, which I believe is numbered 589, Senate Bill 589. And I think that has a joint and several liability component to it. I am not positive it's the same, but this bill to me it just makes it fair that if you're responsible in damages, what you're responsible for in your liability. And that's pretty hard to argue against. And I realize that, you know, somebody's going to say, well, it injures the person that unfortunately gets involved where there's one of the defendants doesn't have any insurance. Well, that is true. No arguing that. But again, if you should be responsible for your money as your responsibility for your liability, and I think that's fair.
Thank you, Mr. Chairman, members of the committee. My name is Jay Atkins. I am the General Counsel and Registered Lobbyist for the Missouri Chamber of Commerce. And I think Mr. Brownlee did an outstanding job of summing up what this bill is all about, and it saves me from going through a history lesson. And I would just say that I think this bill has been out there before. The business community and the chamber certainly support moving towards a fair share or proportional liability doctrine in lieu of the modified joint and severability, or excuse me, joint and several liability framework that we have now. So with that, I'd be happy to take any questions.
Any